Hello, good morning everyone. Thank you for joining us for today's webinar. We are waiting for few more people to join. So please hold on for few minutes. Thank you. Welcome everyone to today's webinar. I would like to welcome two powerhouses of relativity's compliance team leading today's session. So please join me in giving a warm welcome to our guest presenters, Mrs. Pramila and Mr. Arun Kumar. Welcome and the floor is yours.
Thank you, Divya. So, is my screen is visible? Is my
Yes, ma'am.
voice is visible?
Yes,
Screen
ma'am.
is visible. So, okay, okay, done. Yeah, thank you so much. Good morning, all. Good morning, very good morning. I think we are meeting after a 1 month period. Okay. So I just wanted to understand how far the sessions we are handling is benefit for you. Just give a thumbs up. If it is really helpful for you, give a thumbs up in the chat box. That will be motivating for us. Like, is it really helpful for you people? Give a thumbs up. Okay, so before going in for the subject, I would like to have a brief introduction about what relativity do. Okay, so many of you may be newcomers, so for them to understand what exactly relativity do, I'll give a brief introduction about relativity. Okay, and what we do is like we have this figure is giving roughly how many records we handle in a month actually. Okay, so we handle about payroll records roughly about 1.22 lakhs per month, and per quarter we handle transactions of 14.6 lakh transaction per quarter, and so far we have issued form 16s. 5.73 lakhs of form 16s has been issued, and that too with an accuracy rate of 99.49%. Okay. And the highlight is we have the retention rate of 99.69%. So we have the client retention rate as 99.69%. So this is about the relativity. So what we do actually, so we have, before that, we would like to proudly present few clients who are, few of them are semiconductor clients like Nutanix, Infineon, and analog devices. Okay, so and we have mid-sized clients also like Augusta, Navical, Texmo, and Payoda. Okay, and what we exactly do, we do payroll processing and labor law compliance and payroll compliance and TDS compliance, and we have our own HRMS tool and the compliance tool also, and we do provide consultation for HR and for even for the payroll and compliance audit we do. So under payroll processing, what we do exactly is payroll management and payroll compliance. And we have an employee service tool, and we manage reimbursement, payroll reimbursement, and we do audit also and consultation. And if required, we have the help desk service also. And as per the requirement from the customer, we create the standardized, customized reports also for the client. Okay. And under the payroll complaints, we have PF, ESI, PT, remittance, and labor welfare fund remittance, all the statutory filings. And if required, we do consultations and audit, and we have the smart operator tools. And we also offer the help desk. Okay. Under the tax complaints, we have the Q4 filings, and we address any notices that has been issued, and we validate all the investment proofs that has been submitted by the employees. Okay, and we do offer consultation and help desk services under labor law compliance right from registration and what do you say the change any if any amendments comes we'll help you support the client go for a change in the registration or for amending them, and we maintain all the statutory records, and any periodic filing is required we support them, and we do support in handling the inspections or notices which is being issued to the client. We extend a helping hand till the inspection is got closed without any penalties. Okay, and we do have apprenticeship act consultation also, and but then and there if any updates comes across, we also highlight that to the clients. Okay, so and we also have HRMS tool. So HRMS tool handles right from onboarding till exit of the employee. So when we say from onboarding till exit means it includes payroll, attendance, performance management. Okay, so all these are included in this tool. And compliance tool, for easy handling of the compliance, we have our own tool wherein if there is any queries raised by the employee in reference to any compliance means we'll address them through smart operator tool. And for handling any notices, we make use of this tool. And we have a knowledge hub in that tools wherein all the legal updates, the latest updates is being posted. So that gives what do you say, that a quick update on the changes which is happening in the labor law. Apart from that, we have this add-on services like we have the DPDP advisory. What does it mean? The Digital Data Protection Act. So it is advisable to make use of this services because we have to make ourselves prepared before the act is being fully implemented in the year 2027. Okay, so and we have POSH compliance also. And right now, the most happening project right now is the labor code implementation project. We do support in wage restructuring and help the client to implement and make sure that they fully comply and be prepared for this code. Okay. So what is today's agenda? So today's agenda is we are going to see what is industrial relations, a brief introduction of what is IR, and what are the key changes which as an employer, as a compliance professional, as a HR professional, we have to make sure that that is being implemented. And finally, we have a glimpse on the new recent provident fund schemes that is being notified by the government. Okay, we'll be having a small glimpse of those notifications, which will help you out to make yourself prepare for implementation of these schemes. Okay, so of course, obviously, you'll be implementing these PF schemes, but what changes you have to understand and we make sure that you implement on time. Okay, and finally, we have the Q&A session. Okay, so before going in for the subject, I would like to understand the participants. Okay, so just I request all the audience to participate in this poll. So help us to understand, like, what is the, I mean, what kind of participants we have, and the company size, the nature of the industries. So this help us to understand, like, we can cater the program as per your requirement. Okay, so I want 100% feedback of all those participants in this poll. Okay, so employee size, we have I think between 250 to 500 with the 27 percentage. And we have 1,000 plus, we have 500 to 1,000, we have 1 to 100 and 100 to 250. So we have more number of participants with the employee size of 1 to 100. Okay, so that is leading with 29%. And people from which department? Are they from HR, payroll, or compliance? I think we have more of from HR department. Okay, we have 53% from HR side. And going by the industry, we have, I think we have from the manufacturing setup, a huge, I think 42% from the manufacturing setup. That is a good number, followed by others and the ITS with the 26 percentage. I still request all the participants to participate. We have only 76% of people have participated in this poll. I request all the audiences to participate. So this data will help us to cater to your needs actually. So it helps us to frame the program as per the participants. Okay, so we have more number from the what do you say, that manufacturing setup. This is still leading 43%. Okay, so that is good actually. And we have HR with leading 54% of people from HR background. And the company size is 1 to 100. We have more number of people from the company size of 1 to 100. Yeah. Divya, can we? I
Yes, we
think
can.
80% of people they have participated. I still encourage that almost all the people can participate. Okay, so fine. Yeah, thank you all. Thank you. And please give us a feedback in your chat box, like how far we were handling few sessions on the the labor codes previously. So how far this is very supportive or helpful for you. If you have any queries also, you can put it in the chat box. This helps us to understand how far our program is catering the needs of those participants. Okay. So thank you all for participating in this poll. Okay, so we'll have an introduction of the subject. Okay, so we have gone through all these websites, we have gone through all these articles before preparing for this session. So I should be thankful for all these, what do you say that, the website owners or the one who have written those articles. So it includes the government also. Okay. So industrial relations, by this time, you people are very much aware of what is industrial relations code and what all the act that has been subsumed under the industrial relations code. So Industrial Disputes Act 1947. But even then, I just want you to have a fresh recap of what all the act that has been subsumed. Okay. The Trade Unions Act, the Employment Standing Order Act 1946. Okay. Okay. Right. So what does this industrial relations code speaks about? Okay, so it speaks about there are a few things which we have to understand about this. What exactly the changes has happened in this code? Okay, so one is the dispute resolution mechanism. Okay, so they have completely streamlined this dispute resolution mechanism. So they have a structured conciliation and arbitration proceedings with the time bound activity. Okay, so they have to complete this conciliation proceedings within this period and the arbitration proceedings within this period. So there is a streamlining of these mechanisms and what all the machinery grievance handling machineries that is available for any worker in the establishment. Okay. And the act also gives much more representation for the, okay, so this representation, it is in the form of the works committee or in the form of a trade union or in the form of the grievance redressal committees. Okay, so we are going to see all these things, how this is being formed and how the trade union is being recognized. Okay, so if there are more number of workers who are being member of the trade unions, obviously the employer has to mandatorily they have to recognize that trade union. Okay, and yeah, all the compliance is happening digitally. Okay, so whatever the filings, the annual filings they have to employer has to do, it can happen through portal. Okay, so there is the physical, the manual record maintenance is I would say it's obsolete, except for few what do you say that records for evidence. In that case, they have to maintain few manual records. Other than that, the employer they can maintain all the records digitally. Okay, and coming to standing orders, okay, so earlier there was one single sample standing order was available, okay, but right now under this new industrial relations code, we could see three different model standing orders, okay. So as per the sector, the government has notified three different types of model standing orders, okay. So here there is a very prevalent, or I would say that opinion among the employers or the organization saying that this industrial relations code is not for us actually. So for the people who are into the manufacturing setup, wherein you have the unions and the workers, okay, it is not meant for the people in the IT sector. Okay, so that is a very prevalent opinion in the market, I would say, or among the employees. Okay, so the coming forth slides will break all those myths. Okay, so it will help you to understand. So before going in for this deep down delve, into the session, I would like to, I would say that the key takeaways from this session would be like it's like an enlightenment for you people, not in a spiritual way, but a deep insight on the subject of the industrial relations code, making yourself understand whether whether our employer have, as an organization, whether we have to comply with this industrial relations code, whether it is applicable for us. So this gives as an insight for you and help you to take the appropriate steps to implementing this industrial relations code. So I missed out this key takeaways in the introduction. So, but right now, I just want to make sure that what you people can have at the end of this session is, one is to have an insight of this industrial relations code, and the second is what appropriate steps as an employee, as an employer, or I think many of you are from HR background and compliance professional also is there. So and a few people are there for in policy making. So it helps you to take a decision. Okay, so what steps we have to take towards implementing this industrial relations code. Okay, so before that, I just, as I told you, there are few myths which is there in the market. Okay, so we have to break that myths. So they say the people, especially from the IT sector, they have a say that these industrial relation code is not for us. Definitely not for us. It is only for the industrial establishments like manufacturing sectors, the mines, the plantations. Okay, but this coming forth slides will break that myth. Okay. So first and foremost thing is we say that the industrial relation code is applicable only for the factories and the manufacturing setup, or even for the mines and the plantation, and definitely not for the software industries. Okay, whereas the code clearly has defined that what is industry. Okay, so the industry, that it has given a simple definition. It says that any systematic activity that is being carried on through a cooperation between the employer and the employee to bring out any final goods product. It can be a manufacturing product, it can be a distribution of the goods, or it can be in the form of a service. Okay, so when they say in the form of a service, obviously the software sector, the ITES, the BPO, all these company are being included under the definition. Okay, so the government has clearly defined this definition as per the Supreme Court judgment on the Bangalore Water Supply and Sewage Board versus Rajappa. Okay, so based on that Supreme Court ruling, they have gone in for the redefinition of this. What is the industry? So obviously, whoever runs a business, either for satisfying the human needs or wants, they are being simply defined as an industry. What is the exceptional case is only for the spiritual. For example, like if it's at a temple or if it is any charitable organization, that alone is being exempted from this definition. Rest other all the activities which is being performed for the human wants or for the human needs. Okay, so that is being classified as an industry. So obviously, going by this definition, we cannot have an idea saying that we are an IT sector, so the industrial relation is obviously not applicable for us. Okay, so I request all those people, if you have that presumption or if you have that judgment saying that this is not applicable for any IT or ITES or BPO or even for matter of consultation, please have a revisit on your views. Okay, so as per the act, the definition has clearly stated that industry. Okay, so industry is a systematic activity which brings out a production of goods or the distribution of goods or offering any services. Okay, and second myth, what they say is we are an office, we are not factory. Okay, we are not industrial establishment. So that's why we don't have a works committee or standing order in our establishment. Okay, so and the one more step they go and say that especially from the ITITS, the Karnataka state government has issued as order standing order exemption notice. Okay, so I think last June they have given this exemption order stating that all the IT and ITS establishment, they are being exempted from the standing order provisions. Okay, and this has got a validity for 5 years. Okay, but when you go through the exemption order, that clearly has an expiry date. Okay, wherein it's clearly mentioned that when the industrial relations code is being notified, this is being superseded. The industrial relation code supersedes this. What do you say, that exemption order? So whoever, I mean, we have to make sure that the exemption order is no more valid. I'm giving an example of Karnataka. Okay, okay. In Telangana has given some exemption order. So people who are in the IT and ITS establishments, please make sure that there is no what do you say, that exemption, a blanket exemption for all the IT and ITS sector from the standing order provisions. Okay, unless the state government, if they issue any fresh notification, the appropriate state government, like as Karnataka government did last year, if they are coming forth with the fresh one more notification saying that we are exempting again from the standing order provisions for all the IT and ITS establishments, means obviously you can get exemption, but we have to wait for the exemption order from the government. Okay, till such time, the standing order is very much applicable. Okay, so the term industry doesn't restrict only for the factories and mines. Okay, so it clearly states that even the IT and ITS or is also the sector is also included in the definition of the industry. So we cannot simply say that works committee, standing order, grievance redressal is not at all applicable for our establishment, since we don't fall under the definition of industrial establishment. Okay. So when you refer the industrial establishment, it clearly states that any industry is being carried on in the premises. Okay. So when we refer the industry definition, it's a systematic activity carried on with the cooperation between the employer and the employee for bringing out any goods, for manufacturing any goods or the distribution of any goods, or for offering any services. Okay, so we have to be very clear on this definition. Okay, and other code says that why should we have a works committee and why should we have grievance redressal committee? We don't have, and even for matter of even having standing order, we don't have any unions, right? So why should we have that? Okay, so that is one presumption. But having to have a works committee or to have a grievance redressal committee or to have a, what do you say, the standing order, union is not mandatory. Okay, it's not mandatory for any union to be there so that a works committee can be formed, or for that a very grievance redressal committee shall be formed, or for having a standing order. Okay, so union is not mandatory. It is about the head count speaks. Okay, so how many workers are there to have a works committee? There is a threshold limit to have this works committee, the grievance redressal committee, of a standing order. Okay, so we cannot simply associate saying that we are factory, we don't have any union, so we don't have the we don't have to have this works committee or the grievance committee. Okay. So in the sense that unions are not required to form all these body committees. Okay, and there is a one which says that we all have managers. Okay, so we don't have any workers in our organization. All are very highly skilled. We have the, what do you say, that software engineers, testers, developers, analysts, and associates. We have team leads. Okay, so they carry all these titles, which speaks about they are the managers. So they don't have any workers in their organization. Okay, so here what is this we have to understand is there is no relationship between the title and the what do you say, that the nature of job. Okay, so you may have a title as a manager, but you have to look into the duties and responsibilities. Okay, to quote one example, okay, recently we, as I told you, we are doing this labor code project implementation. So very recently we did a one, what do you say, that the classification of workforce. That is the best example I would say. So it's a very key activity to understand, what do you say, that to understand the applicability of various statutory provisions. So how many employees are there and how many workers are there. Okay. So one key activity is to classify the workforce category. So we did this classification and we gave back to the our client. Okay, so the client, they have gone through that and they came back with one question, and they argued that how come a job profile which is in the same level, they had a multiple levels of this position, and they had a multiple profiles also which goes beyond 100 profile. Okay, so they came with a question saying that how come two similar job profiles at the same level, they, one can be an employee and one can be a worker. Okay, so this is a very valid question. So this question has made us to revisit and find out where we have missed out. Okay, so when we revisited the job description, we could able to, what do you say, that we felt relieved and we were happy. Okay, so why we felt relieved means we could able to, what do you say, that identify the key term which discriminates, what do you say, that the employee from the worker. Okay, so the one profile has got, what do you say, that the term decision making. Okay, so that term has clearly discriminated that that profile will fall under the purview of employee, and the one which doesn't carry, which falls under the worker. Okay, so what we need to, why we are happy is, like why we felt, and we felt happy is the client took a call that they have to go and revamp all the job descriptions. Okay. So, what we have to understand from this is just with the title, we cannot decide that whether they fall into the employee category or they fall into the worker category. So, we have to understand the duties and responsibilities, the roles they carry. Okay. So, whether that particular role is empowered in taking any decision making, what do you say, that taking planning or budgeting or directing or being a mentor, all these are roles which speaks about a managerial role. Okay, so the essence of it is we have to go through the duties and responsibilities of the particular profile rather than going by the title. You will be in a trap. Okay, so please make sure that you refer the definition, the statutory definition, which clearly speaks about what is worker and what is who is manager. Okay, so manager is something who is in the managerial position or in an administrative position, who has the power to take a decision, who has the power to take what do you say, that plan, who can do go for budgeting, who is responsible for generating revenue for the organizations. All these key words which describes the managerial role. Okay, so by simply having a title of manager doesn't make sense to club them under the employee. Okay. So another myth is, so we are IT employees, so we don't have any unions. We don't have any unions at our organization. So obviously we don't have to comply with the industrial relations code. Okay, it's not like that. There are few key organizations, especially which is supporting the IT employees. I can just name few: FITE from Maharashtra, NITES, and KITU from Karnataka. So these are all very active organizations wherein all the IT employees, they associate themselves and they can represent on their, if they have any grievances, they can represent through these unions. Okay, so this is a very, what do you say, that fact which we have to understand, that unions are there. There is no discrimination based on the nature of the industry, whether it is an IT or it is manufacturing or it is a mines or plantation. So once you have 51 percentage of workers as a membership in any particular union, obviously it has to be recognized by the employer. Okay, so they remains a sole negotiating union for the establishment. Okay, so the section 14 of this code clearly mandates that any employer who are having any union in the organization, they are, so they have to recognize their union. Okay, so I just want to find out whether you were able to follow, because the power went off in between. Can you give anyone can give a confirmation? Should I have to repeat?
Yes, ma'am, we can go ahead.
Yeah, please. Yeah, thank you so much. And applicability. So these are all just to debunk all those myths. I'm coming out with all these explanations. Okay, applicability. We are a simple shop. We are simply commercial establishment. Okay, so we don't have to comply with the IR code. Okay, it's not like that. Please refer the definition. As I keep on repeating, this is if any systematic activity is happening which brings out the manufacturing of a goods or process or any distribution of goods or services, means it is obviously applicable. And employee status, going by the title, I'm a software engineer, I'm a team lead, I'm a quality analyst. Okay, so just by the designation alone, we cannot conclude that this code is not applicable. We have to refer the definition of the workers. Even the technically skilled, highly qualified people, they can also fall under the definition of the worker category. Okay, and most of the organizations, they go by the global corporate policies. Okay, so they say that we have a very structured global policies for our benefit of the employees and the workers, and we don't have to go for any certification of the standing orders. It's not like that. Okay, if any establishment is having a 300 plus of workers, means obviously they have to go for taking a certified standing order. Okay, And they have many policies also, separation policy. So if a work is not good, if you're not regular in your work or something like that, they have their own separation policy saying that we'll give 1 month notice and we'll pay the, or if we pay 1 month salary, and the termination can happen. So they have their own contract, okay. But the act says that if they are worker, obviously we have to pay the retrenchment compensation and the reskilling fund, okay. So hopefully, I have made you understand that few myths are there, but these myths has been debunked. So we have to understand the two definitions. Okay, so I'll just go through two. You can just have a go through of two definitions. One is worker. Worker means any person except an apprentice, as defined under Clause A of the Section 2 of Apprentice Act, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be express or implied. Okay, but it also says that it does not include who is employed mainly in managerial or administrative capacity, and who are being employed as a supervisor category, and who is drawing wages beyond 18,000 rupees per month. Okay, so they are being classified as a worker. Okay, so we also have to look out for the notification of this wage ceiling limit by the central government. So this is the definition of the worker. Coming to the industry, so as we keep on, we have seen in the previous slides, industry means any systematic activity carried on by cooperation between an employer and worker. Okay, whether such worker is employed either directly or through any contractor. Okay, for the production of supply or distribution of goods or services, with a view to satisfy human wants or wishes. Okay, so it has given exemption, except if it is a spiritual for a religious purpose or for any charitable purpose, any other activity which is fulfilling the human wants, obviously it falls under the definition of the industry. Okay, and even the domestic service is being exempted actually. So these are all the few list of things which is being exempted under the definition of industry. But we have to look in for the definition of notification. Okay, so hopefully, I think I have created a myth, I debunked the myth about the applicability of the industrial relations codes for few sectors. Okay, so obviously we have to refer to definitions. Okay, before coming into conclusion, one is the definition of the industry and the definition of the worker. Okay, so the classification of the workforce between employee and the worker, that is very crucial, because most of the provisions is applicable based on the headcount threshold. Okay, so for to have a proper headcount, we need to classify the workforce correctly. So to classify the workforce, we have to have an appropriate job description. So just carrying a title as a manager doesn't suffice. So we have to have a good job description. Okay, so next we are going to see what is the workers' representation. So why the code is giving a much more importance for the workers' representation. Okay, so at the workplace as a worker, they may have a number of grievances. Okay, so when we say grievances, it can be in the form of payment of salary, not getting the salary on time, or doing overtime, or continuously being engaged in the overtime. They may have a grievances. They may not, they don't have the channel to express the grievances out. Okay, so the code has, it's not only related to the say payment of salary or for overtime, even for what do you say, the termination, retrenchment, and the safe working conditions, the safety at the workplace. All these are grievances for any workers. So as a team, okay, as a representation on behalf of the workers, someone can speak to the management their grievances. So for that, the court has given a provision for the workers to organize themselves as a, what do you say, that about forums. Okay, so one first thing what we can see is the bipartite forums. So what is bipartite forums? That is, two parties are involved in this forming this forum. So that is called as bipartite forums. The first and foremost is the works committee. Okay, so for any establishment having 100 or more workers, so they have to form the works committee based on the appropriate government's order. If the government feels that this industrial establishment should mandatorily have a works committee because they have 100 or more workers, workers, they can simply issue an order to the establishment to form a works committee. Okay, so how this committee can be formed? Okay, so it should have an equal representation from the workers and the employers. Okay, so the total capacity or total membership of this committee should be 20 and not beyond that. Okay, so when we say 20, equal representation from the employer side and from the worker side. So the employer has to nominate from their end, and the workers from their end they have to nominate. Okay, so this is mostly done by the any negotiating unions or any negotiating council. If they have, they will choose the worker representatives. Okay, so this is headed by chairman, vice chairman, joint secretary and secretary. Okay, so the chairman is headed by someone from the employee side, and vice chairman from the worker side. Okay, and secretary from the employer side, and the joint secretary from the worker side. Okay, so if there are female employees, okay, see the number of female, I mean, they also have to be form part of this workers committee. Okay, so how many female employees we have to include is that depends on the number of female employees we have it on roll. Okay, so proportionately we should give the representation for the female workers to be present in the works committee. Okay, so once they hold the office, they have a term of office for 3 years period. So once the 3 years period, again they have to go in for nominating all these members. Okay, and what is their role? Okay, so simply nominating and forming the committee doesn't suffice. Okay, so their objective is to, if any disputes or if any grievances happens at the workplace, they have to resolve amicably. Okay, so the essence of the works committee is to bridge, to have a very harmonious relation between the uh, employer and the worker. Because that is the core aim of this works committee. Employer, this bridges a very harmonious relationship between these two. So what they have to do is they have to meet at least once in 3 months period. They have to meet. Okay, so once they meet, they have to discuss. They have to receive all the what is it, the issues relating to any workplace grievances, like for example, providing the welfare facilities at the workplace, or if there is any issues related to salary payment, overtime engagement, or for any benefits which the worker has not received. So all these are, if for matter of even for retrenchment or for termination, all these matters will be discussed in this works committee. It's not only discussion, they have to arrive at some conclusion, they have to provide some solution to the uh, uh, employer workers. Okay, so they have to record all those meeting minutes. They should have their any records, and when any inspection comes, they should be able to provide all these records stating that for not for the namesake this works committee functions, it is actually supporting the workers at the workplace. So they have to show all those records, what actions has been taken, how this has been implemented. So, and even getting the feedback from the workers. So all this has to be recorded in the, we have to maintain as a record. Okay, so we saw one bipartite forum, that is works committee. Another one is grievance redressal. Okay, so all those establishments having 20 or more workers, it is mandatory to have a grievance redressal committee. Okay, see, I had an experience. I was handling as a HR manager for a factory. So the management is very lenient actually. So anyone who has a grievance, they can simply walk inside the cabin. They will just simply walk inside the cabin and they will express their grievances. Okay. So at one point of time, what happened is one employee, he came and he was the conversation was very casual actually. So he was just casually expressing it out his grievances, and at one point of time, he crossed beyond the line. Means like he started asking some few personal questions to me. Okay, so here nowadays we have all the posh guidelines and all. Okay, so those days I'm saying that 15 years before, okay, we didn't have any posh and all. So it is just a one-to-one communication inside the cabin, wherein there is only no, nowadays we have a spot where we can just simply write on the line. Okay, so this industrial relation code, right, they have structured in a manner saying that It's not just simply walking inside the cabin and expressing out your grievances. There is a structured mechanism for the worker to express the grievances. Okay. So the rule is very much supportive both for the employer and for the worker grievances, but there should be some structured manner to address these grievances. Okay, so the foremost requirement of having this committee is if any establishment is having 20 or more workers, it is mandatory to have this grievance redressal committee. Okay, you can say that even at least even even at one day we had turned committee. Okay, so we cannot while going, if at any point of inspection, if the authority asks for any records at one point of time, if you could show that we had 20 more workers at one period of time, means obviously the next question is, have you formed the grievance redressal committee? If the answer is no, obviously it is an offense. Okay, we are not complying with the act. Number of headcount crosses beyond 20 or more means it is mandated to have this grievance redressal committee, and this committee should have the equal representation from the employer side and the worker side. Okay, so the total headcount should be 10. Okay, not beyond that. And similarly, there is more female employees there in the on roll, means equal representation should be given for the female employees also represent in the grievance committee. So how I'm not happy about me being engaged continuously in overtime for the past few months or something like that. I'm just giving an example, okay? So he can submit an application to the committee stating that this is what my grievance is. So once the grievance is being submitted, committee, what they have to do is they have to discuss among the team members. Okay, so they have to give a resolution to the workers. Okay, so if they say that, if, as I told you, if the queries have been engaged continuously for the past few months in for the overtime, means they have to go for remedial measures. Okay, so they ask both the shop floor people and the worker to come and sit. What is the alternative solution? So first they can decide among themselves, and they can call for the both the parties who are involved, and they can take an action. Okay, so this is how the committee works actually. So the point here is all these can happen within a timeline of 30 days. Okay, so they cannot prolong this decision making. Okay, so within 30 days they have to take a decision. If not, the employer, the aggrieved worker, he has every right to go to the next level of escalating this grievances. Okay, so what the worker can do is, if there is no decision, or even for the matter, if the decision that has been taken by the committee is not, if the worker is not happy about it, means they can go for the next level. Okay, so what they can do is they can approach for the conciliation officer. Okay, so the conciliation officer is being appointed by the appropriate state government. Okay, so that we can see in the coming 4 slides how they are being appointed. So here, once the grievance is being escalated to the conciliation officer, he has to resolve within 60 days time. Okay, so if that is not being resolved within the specified timeline, means very well the aggrieved person can go to the tribunal level. Again, the tribunal is being formed by the appropriate state government. Okay, so here, once it comes to the tribunal level, means mostly the issues like discharge, dismissal, retrenchment, and termination, all these being addressed at the tribunal level. Okay, so here the tribunal has to address this all these serious issues within a span of 2 years period. Okay, so this is how a grievance at a workplace is being escalated. First at the grievance committee level, then at the conciliation officer, then it goes, at times it can go for the arbitration level also, and then next to the tribunal level. Okay. And trade unions or the negotiating council. See, for example, how the trade union is being formed. Okay, so in an establishment, if the 10% of, for example, take an establishment having 500 workers. Okay, if the 10% of the 500 workforce are being associated with any union, means definitely that union can be registered or if they have 100 or more workers, either whichever the number is least, they can go for registration of the union. Okay, so once the union is being registered, obviously it is employers' accountability to recognize that union. Okay, so they have to recognize that a sole union for representation, anything representation of the workers, that will be recognized as the sole union for the employees to recognize. Okay, suppose in case if there are more than one union, such unions are there, means here we have to take about the what do you say, that head count percentage. Okay, if there are 51 percentage of members, the workers are being members on that particular union, means obviously they can recognize the union which has got 51 percentage of the workers as a members, means they can recognize that as a registered or recognized trade union. Okay, suppose in case they have multiple unions but no union doesn't have a 51 percentage of membership, means they can go for forming the negotiating council. So how this negotiating council is being formed means, from each union, that union should have at least 20% of the membership of the workers. So all those unions, they can nominate one person as their representatives, and this is how they can form a negotiating council. Okay, so this negotiating council is also being it is meant for representation of the workers. Okay, they can speak on the behalf of the workers. Okay, and once this council is being formed, this is valid for 3 years period. Okay, so coming to standing order. So why standing order? Standing order is nothing but it speaks on the terms and conditions of the employment. Okay, so the attendance, the leave, how to avail leave, if there is absent, how it is being considered as a LOP, and how the leave is being accumulated and how it is being carried forward. I'm just giving one example. Okay, and if there is any grievance at workplace, what are the grievance addressing machineries, whom they have to approach, who's the right person to approach. All these we can see in the standing order. Okay, so here, as I told you, the Karnataka government, they have given an exemption order stating that IT and ITS establishment, they don't have to comply with the standing order. But that notification has carried a disclaimer saying that this exemption is not is up to till the industrial relations code is being notified. Okay, so that exemption order is no more valid. So all the establishments which is having 300 or more workers at any point of time for the past 12 months, they have to have a certified standing order. Okay, so as I told you, if any authority visits the establishment and if they just scroll through all the past records, and if they find out that at any point of time the workforce head count, the workers head count has crossed beyond 300 or more, means obviously this provision of the standing order is very much applicable. If they fail to have the certified standing order, they are liable for the offense penalties. Okay, so how the certification works? Okay, so the employer, they can prepare their own standing order. Okay, so they can draft their own standing order. How they can, after drafting the standing order, they have to go back to their workers representatives. If they have a union, they can consult with the union members. If they have the works committee, they can ask for the works committee members consent. So they make sure that the workers representatives or the unions, whoever it may be, they have gone through all the details of the standing order before going in, submitting it for submission of in certification to the authority. So once they have signed the draft, it can be forwarded to the appropriate authority, the certifying authority. So they can send it. Earlier, we have to submit multiple copies. All these are manual copies. Okay, so we have to have a continuous follow up with the authority so that we receive the standing order certified within a 6 months period. Okay, so now the code has streamlined this activity. We don't have to take multiple copies. Okay, we don't have to have submit any manual copies. Okay, we can simply draft the certified standing order. We can apply through online through the certificate officer, and within the timeline, I think it should be 30 days or 60 days. Okay, not sure, but within the timeline they have to certify the standing order. Okay, so what all the details we have to provide? As I told you, all the terms and conditions of the employment, it has to be there. and we have to have capture all the name and the address details of the establishment. We have to capture the representatives details from the worker side, their contact number, the total workforce strength, how many workers are being employed, their categories, all these has to be provided in the draft. Okay. So once the authority is satisfied that, oh yes, they have taken the consent from the both the workers side also, they can go for the certification of the standing order. Okay, so this is one way of getting a certified standing order. Okay, and once the certificate standing order is received, the employee has to make sure that they keep that display on prominently at the workplace, so that every workers they can have a go through on the orders. Okay, and we have to make sure that this standing order is displayed in three different languages: Hindi, English, and the local language, where the more number of workers they understand that language. Okay, so in that language, we have to display the standing order. So earlier it was two, but we have to display it in the three languages: Hindi, English, and the majority of the workers they understand which language, whichever the language they understand. In that language, the standing order has to be displayed. And coming to the model standing order, the act is very flexible actually. Okay, so it is making the work of the employer very easy. Okay, so they have arrived at a very model standing orders. You can just have a go through on that. They have clearly notified for different sectors. Okay, so Schedule A speaks for the mining sector, and Schedule B for the manufacturing sector. Okay, and Schedule C is for the service sector. So all the IT and IT establishments, the consulting firms, all these they have to, if they want to go for a model standing order, they can adhere to the Schedule C of the model standing orders. Okay, so if they are adhering to the model standing order, what they have to do is they can simply intimate to the authority saying that being a service sector establishment, we are adhering where the service Schedule C of the standing order. Okay, so a simple intimation is sufficient to intimate to the authority. Okay, so now we are going to see what all the industrial dispute handling machineries are available in the establishment. Okay. So as I told you, we have the conciliation officer, we have the arbitration officer, and we have the industrial tribunals, and we have the national tribunals. So conciliation officer is one which is being appointed by the appropriate state government. So they will choose the appropriate officer for each jurisdiction. Okay, so the aggrieved employer worker can approach the respective conciliation officer to address the issues. Okay, and industrial tribunal is a two-member tribunal which is being formed by the appropriate state government. So one member is from the judicial background and one from the administrative background. Okay, so what are the disputes these industrial tribunal they can handle is, so one is if there is any dispute regarding the interpretation of standing order means they can resolve that dispute. Okay, and if there is any dispute regarding the discharge, the dismissal of the workman means they can also refer this to the industrial tribunals. Okay, even for going for a strike or lockout, or for matter of retrenchment of the workers, or if there's any trade union dispute, if there will be a dispute even among the trade union also. So in that case, the industrial tribunal can address all these issues. Okay, and the National Industrial Tribunal. So here, when the problem is not related to one state, if it involves multiple states, means the central government is responsible to form this National Industrial Tribunal. Okay, so if that dispute is of national importance, means obviously it is a central government who has to form this National Industrial Tribunal. So all these, if this the disputes which involves more than one state means they can be addressed through this in the National Industrial Tribunal. So strikes and lockout. Okay. So before going in for strikes, the Act has given some clear guidelines also how the strikes can be. Okay. So again, I wish to quote an example from my experience. So the company which I worked was located in an area where the IR issues or the IR unrest is quite prevalent in that area. Okay. So it was a Deepavali time actually, and we had to dispatch the goods. We have to manufacture and dispatch the clients which are located abroad actually. So it was a huge order, and we have to make sure that each day is very crucial for us. Okay, so what happened is a few group of workers, they sit and they went outside the shop floor and sat at the entrance of the gate. So what you call as a sit-in strike. Okay. So unexpectedly, they know pretty well that there is a timeline for delivery. Okay. So knowing all these things, commitment, they want to give what do you say, that pressure to the management to put forth their demands and to have their demands is fulfilled. Okay. So they went inside, they went at the gate entrance and they simply sat in. They didn't do any work. Okay. So we cannot either say we cannot have, I mean, it's a very, what is a delicate situation. We cannot manhandle them actually. You can simply request either they go and go back to the shop floor and do the work, or they can simply take a leave and move out. Okay. So that was a simple advice given. We didn't even ask for what reason they are sitting and striking. I mean, sitting in doing the strike. Okay. So what happened is for few hours we simply ignored. They didn't come forward and disclose for what reason they are sitting in and doing the strike. Okay. So we just ignored for few hours and automatically they cooled down and they came out and put forth their demands. Okay. So these are all we had a technique where we could able to handle that. Instead of escalating a situation, we were adopting a technique which is feasible for us at that time, at that point of time. But now the industrial relational code has brought in few guidelines. Okay. So now it has been made mandatory that anyone cannot go in for a strike simply if they feel that I'm not going to wish to work. They can go and decide and go for a strike. It's not like that. They have given some guidelines. Okay. So a prior notice has to be given to the employer. Okay. At least a 14 days period should be given in prior, so that management, the employer, whoever it may be, they can understand what is the issue. So instead of going in for strike, they can simply sit with the workers' representative and they can resolve the dispute. So instead of going in for strike and losing the, what do you say, the time, the money, they can sit and discuss even before that. So that is a cooling off period, we can say that. So the 14 days notice shall be given by the party who is going for the strike. Okay. And they once they have announced that we are going for a strike for the so and so date, means they should not go in for a strike even before the date they have mentioned. Okay, that is not allowed. Okay. And even at the time, if the dispute is being resolved at the conciliation, if any proceeding is happening at the conciliation level or arbitration level, or if the dispute is at the tribunal or national industry tribunal level, means they should not go for any strike if the issue is being addressed by the all these levels. Okay. So even after the decision taken by the conciliation officer, they should not go in for the strike within 7 days period of time. And if it is a tribunal, means within 60 days time, they should not go in for the strike. Okay. And even they would have given some award, the settlement they would have produced. Okay. Even during the operation of that settlement, no worker is allowed to go for the strike. Okay. So this is empowering. I would say that this is empowering the employer to take action if anybody goes for a strike unexpectedly without any prior notice. Okay. So that is very much protective even for the employer. Okay, so retrenchment, layoff, and closure of establishment. Okay, so here, what is retrenchment? Okay, retrenchment is for various other business reasons. The employer decides to send the worker. Okay, terminate any worker. Okay, it is not kind of any disciplinary action, or it is not any voluntary retirement, or it is not any expiry of any fixed term contract. Okay, it is all purely a business reason what do you say, the terminate the employer. Okay, so to terminate the worker. So before going in for retrenchment, there is a guideline, there is a procedure which the employer has to follow. Okay, so he has to select, if there is no any agreement. Okay, if there is any policy or agreement between the employer and the worker, means they can go for this procedure. One which has been the last recruited worker, they can be selected as the person who has to be retrenched. Okay, so once they have shortlisted and selected, means they have to give notice to the particular worker, clearly stating the reason for what reason the worker is being retrenched. Okay, so a 1 month notice shall be given along with the reason. Okay, clear cut reason has to be mentioned. If they are not going for 1 month notice, if they can pay 1 month salary also, they can go for it. Okay. So along with the retrenchment, what they have to pay is retrenchment compensation they have to pay. So retrenchment compensation, who is eligible for is those worker who has completed 1 year of service, they are eligible to receive this retrenchment compensation. So how many years they have completed this service, the 15 days average salary for those many years they have completed, they should pay as a retrenchment compensation to the worker. Okay. So while doing this, simultaneously they have to intimate to the authority about this retrenchment. Okay. Suppose in case within 1 year period, the employer decides to recruit for the same position, means the preference has to be given to the worker who has been retrenched. Okay, so that is the key point the employer has to understand that. Okay, so if they are going for filling the vacancy within the same year, means they have to give an opportunity for the worker who has been retrenched. Okay, and those establishment which is having 300 or more workers, before going in for retrenchment, they have to seek the permission from the authority. So they have to take the prior permission from the authority before going in for the retrenchment. So this is how we need to understand that even for IT or ITES, or if for the manufacturing sector, those the management, if they decides for retrenchment, means they have to give the retrenchment compensation. So and they have to give opportunity if they're going for recruiting for the filling the vacancy in the same year. Okay, and intimating the authority is also mandatory. Okay, and seeking the prior permission before the retrenchment is mandatory for those establishment which is having a 300 headcounts. Okay, and workers reskilling fund. So what is workers reskilling fund? The management has decided, so this worker has to be sent out. Okay, so what they have to do is they have to pay the reskilling fund of 15 days wages, last round wages. 15 days of wages has to be paid. It should not be paid directly to the workers. Instead, what they have to do is the amount has to be deposited to the authorities account. Okay, this account we may come across to know, like once the government, appropriate state government notifies, we may able to understand who is the right authority to whom this account has to be transferred. Okay, the bank account details will be available in the portal. So to that account, the employer has to transfer the fund. Okay. Well, so what government receives, they do is once they receive that amount, they also equally contribute the amount to the worker. Okay, so they transfer that amount from their account to the worker within 45 days period. So once they receive it from here end. Okay, so this fund will help the workers to upskill him to what do you say, that to upgrade himself for the finding out a better opportunity. So this is kind of a supporting fund for the workers. Okay, and transfer, layoff, and closure of the establishment. So transfer of establishment. So suppose the management decides to transfer the ownership of the establishment to some other management, means they have to provide the compensation to the workers. Okay, so workers who have been completed 1 year of service, they are entitled for this compensation. So before, they have to give that notice also to the workers, saying that this is the reason the management is going for the transfer of the ownership. Okay, and similarly, if the management decides there is a less production period, so if it decides for a layoff, means they have to give notice for all those workers which they have decided 1 year of continuous service. They have to give notice, and along with that, they have to give them a 51% of the basic plus DA for the days which they have been laid off. Okay, so that is mandatory. And for closure of establishment, if the management decides for various other business regions, they're going for closure of the establishment, means they have to intimate to the authority about the reason for closure. Okay, and they have to provide the compensation to the workers who have at least completed 1 year of service. Okay, so the average 15 days salary for it should be multiplied with the number of years they have completed service in the organization. So this is the procedure they have to adopt. See, all these we have to the respective forms. We have to refer the appropriate state government notices. Okay, so we have to look in for the wait for the notification from the appropriate state governments. Okay. So I just want to give a highlight of a few court findings. about these industrial relation applicability for the IT and ITS sector. Okay, so there is one case. Actually, this happened in the year 2014 or 15. Okay, so Sasireka Tangavel Natarajan, she's an employee, IT employee with the designation as an assistant software consultant from TCS. Okay, she was terminated at the maternity benefit period. Okay, so she was not happy. So what she did is she approached the labor court. Okay, so the labor court decision also was not happy for her. I mean, she's not happy for the labor court decision also. So she approached the high court. The appeal. She went for an appeal for the high court. Okay, so the high court, after scrutinizing all the background of this termination details, they arrived at a conclusion that the employee, the employer was saying that she is an employee, but the court decided that she is not an employee, she is a workman. Okay, and even they went forward saying that TCS is also fall under the purview of definition as an industry. So going by the definition as a workman and the industry, the court has give an interim injunction order stating that employer should refrain from giving the termination order. So going by the order, the employer has revoked the termination order, and subsequently she was reinstated into the employment. Okay, so this is one classic example we can say. See, this is the definition they have referred is as per the Industrial Disputes Act. Okay, and one more, what do you say, the judgment we can say both is Ramesha versus HCL Technologies. Okay, so I think this happened during the year 2016. So this employee was terminated on the ground of poor performance. Okay, so this company has their own policy, separation policy, wherein they have a statement saying that those who are performing poor, they will be terminated as per the company's policy. Okay. So going by this, the court referred the definition of the worker. Okay, so though they may be a software developer or a tester, whatever may be the designation they carry, but going by the nature of responsibilities, that particular employee has been classified as a worker, and going by the definition, the court has asked to revoke the termination order. So based on the court judgment, they have revoked the termination order and they have reinstated the particular worker. Okay, so what we have to infer from this court judgment is simply by carrying the designation as a manager doesn't suffice. Okay, so we have to look into the nature of job descriptions. Okay, so we have to, if they fall under the purview of the worker, means we have to strictly adhere to the provisions given for the workers. Okay, so we have to go by the what do you say, the termination procedures. We have to go by the retrenchment procedure with the notifications and the compensation. Okay, so with that, I think I have given light on the industrial relations code. What as a HR profession or as a compliance professional or as a policy maker you have to do is it is advisable to revisit all those HR policies, which is referring to the grievance or dispute resolution mechanism. Okay, so whatever the grievance mechanism we have to go through that, and we have to revamp those policies. Even the disciplinary policies, whatever we have to revamp. And if we have a standing order, it is advisable to revisit the standing order and get a fresh certification. And if we are classifying the workforce, if we are revisiting and classifying our workforce, means as an employee and worker, means obviously we have to reissue the appointment orders. Okay, so these are all few HR policies which, as a policy maker, we have to what do you say, that revisit and revamp, and we have to make sure that all those policies and guidelines which we have right now, it is as per the statutory framework. Okay, so this is mandatory for all the what do you say, the employer to have a relook into these all those policies and the procedures. If we have any, do we have any grievance committees, or do we have any works committees, or if really the standing order is applicable for us. So all these, what do you say, that we have to, a simple audit kind of thing we can have, and we can just find out wherever there is any loophole, where we don't adhere to is, it is advisable to take immediate steps to comply with the industrial relations code. Okay, so with that quote, I'm ending this industrial relations part, And if you have any queries, please put that in the chat box. I will address that at the end of the session. So meanwhile, I'm handing out to Arun, my colleague, to have a glimpse on the EPF, EPS, and EDLA notices, which was issued very recently. Okay. So Divya, Arun, over to you. Thank you.
Yeah. Thank you, Pramila. Hope I'm audible. I think considering the time constraints, I think we have planned a 1 hour session. Considering the time that we have, I think this PF amendment scheme predominantly requires a lot more time to brief. I mean, the explanations are more. I think we should consider having one more session. So that's what my colleague also feels. I think Divya feels that we will have one more session to explicitly have this EPF discussion. So I think we will shortly announce the time. I mean, maybe next week, early or mid of next week, we will have one more session explicitly for Provident Fund amendment schemes, where we will discuss what are all the amendments and what will be the impact. All those things will be discussed. I hope you are okay with this. And now I think we will be having a lot more questions regarding this IR. I think Pramila took extensive presentation and she briefed everything which is required with respect to the employer compliance. So you can post your comments, and also you can post your questions if you have with related to IR. We are happy to answer, and we will shortly announce one more hour of discussion on this PF scheme. So we will shortly connect. Yeah, those who are having questions related to this IR session, you may post in the chat where we'll be responding to that. So we'll take another 10 minutes to wind up this session. Thank you.
Thanks, Arun. Now only I realized that I crossed the timeline. Yeah,
Yeah,
thank
I
you.
think it requires definitely it requires more time to explain, Pramila.
Yeah.
I hope that we have an enlightening session. So not an issue. We will consider one more session explicitly for Provident Fund. No, not
Yeah,
an issue.
that is a good decision. Yeah. Yeah, I request all the participants, if you have any questions, please post your questions. Um, Okay, so it's a question from Praveen Prasad. Does this area applicable to real estate industry also? See, as I told you, okay, so industry is a systematic activity which is happening. Okay, definitely the IR is applicable for the industry, real estate also. So we have a feedback poll also. Please address. Please, I would like to. I encourage all the participants to please give a feedback about this session. This will help us to, what do you say, that a better presentation in future if there is any requirement from your end. Okay, so I want to understand how far this session is benefit for you, whether it is useful. So earlier, as I told you, we were handling earlier a few more sessions on labor code. So exactly whether this is helping out you people in making any decisions or implementing any compliance changes. So that will be helpful for us actually. So your feedback is very important. Are contract employees eligible to form a union if they are on third party payroll? Yes, they can. They can form union.
I think
Thank you,
Pramila,
Yashoda.
there are more questions in the top. Maybe you can review and respond to that.
If you were saying that the screen was not available, I hopefully you can get the slide PPTC. Please, you can go through that. Is it applicable for logistics? Yes, it is applicable for logistics. What about people working? So that question is from Prakash, okay? And Satish from, what about people working in contract roles? Are we eligible for unions? Yes, everyone is eligible to form associate unions. As I told you, the membership matters, the head count matters. Kiran, wages drawing 18,000 is basic plus DA or fixed gross salary? Wages. Okay. Could you please share the slides to the registered? Yes, obviously we will share the PPT. Yeah, thank you. Can you share? Yes, yeah, people, most of them are asking for the PPT. Yes, we will be sharing it. Thank you, Yashoda. Thank you all. Are contract employees eligible to form union? Yes, obviously. This is from Satish Ram. I think this is being repeated. Thank you, Satish. Thank you, Gopinath. A great initiative by, thank you, Kiran. Thank you. A great initiative by you, EPF for next session. Thank you. Yes, definitely, Kiran will be organizing this session. Okay, this is from Sunil. Establishments having more than 100 workers need to have grievance redressal committee as well. Yes, definitely, they should have. Kaveri, if notice time is not served by employee, can we deduct the salary as per the appointment letter? Yeah, that is, I mean, you are asking that if any employee is not serving the notice. So since this question is for employees, yes, obviously you can go by whatever the employment terms and conditions you have. Manasa Shetty, session was really good. Yeah, thank you so much, Manasa. We will organize similar such sessions. Yeah. Ragini Goyal, the two cases that you mentioned about tribunal ruling against worker retrenchment, could you please explain? Of course, the time is a shortfall. Okay, so we could not able to go beyond that. Okay, so the essence of it, what you have to understand is we have to refer the definition of the worker before going in for taking any action. Please make sure whether the particular category is falls under the purview of the definition of the worker. If it is worker, please adhere to all the whatever the guidelines that has been given in the act. Praveen Prasad, very useful session even for non-HR candidates also. Looking forward for it. Yeah, please, we will organize, okay. Pushpalata, thank you, Dhanush. Deepak, what is the protected workman and can management take disciplinary action? So what do you mean by protected workman? No, the question is not clear, Deepak. If you could say what it is exactly, we can answer, okay. Dhanushya, thank you. Pushpalata, we have IC committee for POSH. Do we still need to have separate? Yeah, please. See, the IC committee is for the specific genders, okay. So this grievance committee is for anybody can come and address, okay. So it is not gender specific, this grievance redressal committee, okay. Kiran, exemption under IR by worker, wages drawing. See, that is for the supervisory category. Okay, so supervisor who is drawing 18,000 and above, they are being classified as a what do you say, that employee. Okay, but if you go and see the job description of the supervisor, just because he is holding the title as a supervisor, but his nature of job is nothing but a simple worker category of work, means he don't fall under the definition of worker. I mean, fall under the definition of employee. Okay. So, Gopinath, is principal employer responsible for contract employees' grievance? Yes, very good question. Yes. So, if the contractor fails to address the grievances, it is the principal employer who has to address these grievances. We have it in the OSH code also. Okay, wherein in the principal employer's accountability, it is the accountability of the principal employer to address the grievances of the even the contract workers also. Protected under the Industrial Dispute. Oh, so please see, the Industrial Dispute Act is being subsumed. Okay, so please don't refer those. Okay, so we have to go by with the Industrial Relations Code right now. So any more questions still you have? I think they have responded to all the feedback, Divya. Can we just, I think almost everyone has 87% have responded to the feedback. Okay. So thank you. Can we end this session? So if you still have any questions, you can please post in the mail. Okay. So we will address all those queries. Okay. So thank you all for the participation. Hopefully we can come across few more sessions like as you wish. Okay. So thank you so much. Thank you, Praveen. Thank you. Thank you all. So
Thank you.
thank you. Thank you, Pushpalata. So can we end the
Thank you,
session,
everyone.
Divya? Yeah. Thank you.